I am going to call to order the virtual meeting of the Lost Pine Groundwater Conservation District monthly board meeting on Wednesday, March the 17th, 2021 at 7:03 p.m. This is a telephonic video conference meeting pursuant to the Office of the Governor's temporary suspension of the certification of certain open meeting act laws due to the novel coronavirus. So we're called to order. I notice we have several people that have chimed in, and we've had people request to address the board tonight. I will drop down to that item. Item number 3, public comments. I have had 5 people sign up this evening to address the board. Under public comment, I have had Linda Curtis sign up, Nancy McKee, and Dan Martin. I have had Steve Box sign up for items 10 and 11. And Mr. Box did send a letter in this morning, and I know that Peggy sent it out to the board. And Andrew Weir has requested to speak under item number 11.
President Talbot.
Is it? Yes.
We also have Michelle Gangus would like to speak under items 3 and 10.
3 and 10?
Yes, sir.
Okay.
President Talbot, also Linda Curtis would like to yield her time for Dan Martin and Nancy McKee.
Is she splitting it? I mean, is she wanting to do it?
I guess
She's
a minute and a half each.
Yeah, a minute and a half each. I mean, I just like know how she wants to do it. Because I guess that's what I'm going to do if that's what she wants. So,
okay. Well, I mean, she can.
Can I just say something real quick?
Yes.
I'm pretty sure that Nancy's going to hit about 3 minutes, Chairman or President Talbot. I just didn't want her to get cut off. And we rarely see her, so I want to be nice. And then Dan Martin, I think, probably has more longer comments. And I won't say anything other than what I just said.
so do you want how do you want minutes to go to Dan?
If you could give Nancy just like 30 more seconds and the rest of my 3 minutes, 2.5 minutes to Dan if he needs it. He may not need all that extra time.
Okay.
Thank you.
Michelle wants item number 3 and item number 10. Anyone else? Okay. Then with the first person up is Nancy McKee for item of public comment. And Nancy, you have 3.5 minutes to speak, and you may start now.
Okay. Can y'all hear me now?
I can.
Hello? Okay, good. Thank you. My name is Nancy McKee, and I live on County Road 411 in Lee County. My address tonight is a return to the written comments I submitted to the board December 16th of 2020. At that time, Agenda 9 was the consideration of forming a monitoring well committee and a legislative committee. To date, I have not seen this agenda item addressed, nor some sort of progress report provided to the public by way of board agenda items. Honestly, all I have is a confirmation that my comments were received by Lost Pines. For lack of any other response from Lost Pines, I'm not sure the board members even saw my comments. So I am asking tonight, where are we on this? As to the legislative committee, guess what? Our state legislature is in session. While you have an agenda item that is to give a report on legislation, related legislation, and or activities occurring that affect or pertain to the district and groundwater, this only gives an update of what's going on within our legislature and is but a passive informational report. A committee, I would hope, would contact our House and Senate members with the idea of presenting some serious issues facing Lee County and its water and water wells, as well as constant issues to which the board is faced having to do with drawdowns by those with commercial permits. When does the board propose to have this committee formed? It should be a high priority matter. Again, there has been no agenda item that would discuss the progress of the formation of a monitoring well committee. Meanwhile, the water grab continues, and obviously the corporations are getting more and more aggressive. Information won't be formally collected until a committee is formed. So here we go again, discussion of what to do, but nothing moves forward. And meanwhile, this problem is the old kick the can down the road. Respectfully, this problem is not going away, and history will show that nothing was done to protect the individual's water rights when this trumpet was constantly heralded by the watchmen long, long ago. I did notice that the board will consider this evening hiring an assistant district general manager or the usual consideration of a board retreat or workshop, conference meetings, and so on. There are grave issues Lee County is facing. We don't have the luxury of each month considering future retreats or added personnel. Lee County well owners deserve far more than this. Lastly, I would hope that the virtual phone call board meetings will discontinue. There's a strong disconnect when people cannot attend a person-to-person meeting. Believe it or not, there are still people like me who find computers a bit intimidating. With the seriousness of our future water resources in the hands of board members, legislators, and corporations, we need to have the opportunity to meet face-to-face. With masks, space distancing, and hand sanitizers, there really is no excuse not to return to open meetings. This should be an agenda item. Thank you for your time.
Nancy, all I'll say is that the monitoring committee was created by action of the board. The board serves as a legislative committee, and pursuant to the request of our legislative consultant, the officers of the board I appointed as the executive committee to coordinate with our legislative consultant on groundwater issues affecting the groundwater district. So action has been taken on both of those items, and a document was created so the job of the monitoring committee was spelled out.
Okay, so are you saying that there is somewhere written where we know who the members are, what they're doing?
Yes.
Okay.
Absolutely. Just get a hold of the district. Just call the district and they will be able to get that.
Mm-hmm. Yeah.
Okay.
Okay.
All right. Next is Dan Martin.
All right. Can y'all hear me? Am I coming through?
Yes, sir.
All right. Well, I want to talk about the water situation in Lee County as well. I live in northeast Lee County, about a mile from the Burleson County line. Back in December, my well went dry. Called the local well guy, who happens to be a friend of mine. So let me put that out there first. He came down, measured my well, said, "You're out of water. We're going to have to lower your pump." Added 40 feet to the pump, and pump wouldn't pump it up anymore. There wasn't any. We still weren't in water. And so he started doing his magic and measuring and seeing where the water was. And he said, "Man, I got some bad news for you." He said, "We're going to have to lower your pump about 200 feet. And I'm like, wow, what is that going to cost? And he told me. And I said, well, how do I go about getting permission or reimbursed from Lost Pines to get this thing fixed where I've got water again? And he said, well, you just send them a bill. And he said, that's what your neighbor over here did. And we have had in about, a mile area, I would say 14 to 15 wells go dry, just on 696. Wayne works all over the county and has, besides repairing all the broken pipes from the freeze, he's handling all these wells that have gone dry too. Well, I found out that that Lost Pines didn't have any plan to reimburse the Lee County guys for their water, nor have they paid for the water that they're pumping out from under our property. My goal here tonight is to try to see if I can set up a one-on-one meeting, as opposed, like the other lady said, as opposed to video conferencing. Set up a one-on-one meeting so that we can start figuring out how these people are going to get reimbursed for their wells. And we were talking to a hydrologist or an engineer about it, and he said that we can expect the well to go down about 100 feet by 2025. It can go down 200 feet by 2030, and it'll go down 300 feet by 2050. And that is a massive amount of water, and nobody, I think, is going to be prepared to drop their wells 300 feet just to get the water that they had there before y'all moved in. So my number one thing is, if we could get together, try to figure out something that's fair and equitable for both Lost Pines and the homeowners out there, the landowners. It would put me in a bind if I didn't have well water. Couldn't afford to take care of my place and take care of my cows. I give them fresh water, use the water to medicate the cows with, and practice good husbandry, if you will. On the monitoring side of it, the same engineer was telling us that my particular well and another well in Lee County would be perfect monitoring wells for Lost Pines. And so I wanted to find out, is there any effort going on to actually set up monitoring wells and to track what is going on, so that all of us don't get caught with our britches down again? And we kind of suffered a double whammy with the freeze, and then the folks that are still running out of water. Wayne can't hardly conduct business. He's a second generation well pump guy, and he's bringing his son into the business as the third generation. The son has a degree from A&M, I believe, that has to do with the science of aquifers and how they work, etc.
Mr. Martin,
Yes, sir.
you have, I've allowed you to exceed your time. I would suggest that you call Mr. Taunton at the Groundwater District and set up a meeting with him to further the discussion regarding the issues that you have raised this evening. And because this is not an action item for the board tonight, so there's nothing the board can do tonight, but to address your initial concern is to call Mr. Totten and set a meeting up with him.
Okay.
All right.
All right. I
Thank you,
appreciate the time.
Thank you, sir.
Thank you.
Michelle? Angus, Michelle? Did we lose?
Mr. President, can you hear me?
No, I can hear you. Yes, ma'am.
Okay. Thank you. You took me by surprise because I figured I was at the end of the line. I'm not going to spend 3 minutes speaking to you because I couldn't do any better than Ms. McKee and Mr. Martin have done to relate to you why the Simsboro Water Defense Fund keeps coming to you about wells going dry, and we talk to the public about it. We get calls and people are upset. So I'll just emphasize how important I think it is, and others agree with me, I think, that a landowner be able to get a meeting with your committee or with some components of your committee, not just with the general manager. That's not aimed at Mr. Totten at all. It was simply, they need to know that the board's involved, and they need to know who the members are, and they need to know that they can talk to them.
Okay.
And they're ready to talk. They don't want to go through the preliminaries each time. I think several people have called the district, and it seems hard to even get anybody out to gauge wells or get moving on just understanding what's going on. So I'll just implore you to get your board involved, your board members who are on that committee involved. Let them interface with the public so that people have confidence.
Okay.
And that they know that you're trying to address this situation. It's gone on for a few months, and I wasn't even sure that you'd announced the formation of the committee because I can't always hear your meetings. So I'll stop there and thank you very much.
Okay, thank you. Okay, that is all the requests I've had for item number 3 this evening. We do have some additional requests for items later on in the agenda.
Mr. Chairman, this is Andy Weir, and I did email in my request was to speak on number 3 and number 11 of the agenda items.
I'm sorry, that's fine. Go ahead, because it only showed item 11. But go ahead.
Okay, thank you. My name's Andy Weir. I'm a resident in Bastrop County. I have a well in the Simsboro formation of the Carrizo Wilcox. Tonight, I wanted to talk to you about the legislative session and to inform the board about Senate Bill 946 and the companion to that, House Bill 3619. This legislation is important to me as a landowner. It's important to the landowners that you've heard from tonight, and to Simsboro Aquifer Water Defense Fund. The bill essentially adds exempt well owners to those that have to be considered before a permit can be granted. So basically, standing gets us a seat at the table, but then we want you to consider the impacts on our wells. And that's what this piece of legislation does. I've been working with Senator Sarah Eckhart to get this submitted in the Senate, and she did file that bill. And I worked with Representative Tracy King, chairman of the Natural Resources Committee, to file, this is his legislation from 2017, actually. And I worked with him to get it refiled in the House with Representative Rita Bowers. I've spoken with Representative John Cyrier, our representative in Bastrop and Lee counties, and he is 100% behind these bills and thrown his support in. So we've got bipartisan support for this legislation, and I think it's really important. It gives you another tool I hear often that you feel like your hands are tied when it comes to responding to landowners and the concerns that we have for our wells. This legislation will provide in the water code the tool that you need to fully consider our needs and the impacts on our wells, on our property rights, the impacts on our potential businesses, livestock, et cetera. The second bill I would like you to be informed about is House Bill 2851. And this bill, submitted by Representative Lucio, would add to the formula for creating the desired future conditions, which is a later agenda item tonight. It would say modeled sustainable groundwater pumping. That's what would be used in the formula. And so one of the things you'll notice in all of your considerations of desired future conditions is you never hear the word sustainable. It's always, deepening the drawdown, making it more and more to accommodate more and more production. And no one's ever asked, is it sustainable? So this would provide that in code and allow you to have a working formula that for modeled sustainable groundwater pumping. So I just wanted that to bring that to your attention.
Okay. And your
just
time is
remind
up.
you. Thank you.
You bet. Thank you. Now, is there anyone who else would like to address the board before we move on? There's no one else that wishes to address the board under public comment. Okay, then we will move on with the agenda. The item number 4, review and approval of the minutes of the January 20th, 2021 regular board meeting. Those minutes were included in your packet for the board to review and consider. And I'll entertain a motion if some would like to make a motion for approval.
Mr. President, I make a motion that we approve the minutes.
Okay. Board member Fleming makes a motion. Do I hear a second?
Samang will second.
Okay.
Your Honor, however, on page 1 of the January 28 minutes, we need to correct Ray Rogers to K. Rogers,
Yes.
board member.
Yes.
If
Okay.
Mr. Fleming will accept that.
Only because you said it.
Thank you, sir.
You're welcome. Thank you.
We've had a motion and a second with one correction to approve the minutes of the January 20th, 2021 regular board meeting. Is there any questions from the board? Anyone?
Mike,
Yes.
I think Mr. Samang was talking about the minutes of the January 28th meeting and not the minutes from January 20th.
I was, and I stand corrected on that.
Okay.
I thought we were doing both of them.
Okay.
Yeah, we'll pick it up in the next item.
Okay, thank you.
Okay. Thank you. So the 20th stands as presented with the motion in the second. Anyone not approving the minutes? If not, the minutes are approved. Item number 5, review and approval of the minutes of the January 28th, 2021 LCRA hearing in your packet for consideration by the board. And if the board finds them acceptable, I will entertain a motion.
Mr. President, I make motion that we approve the minutes for the January 28th, 2021 meeting. But I did notice that we have Kay Rogers' name listed as Ray Rogers. If we will change that, please.
The Mang second, Your Honor.
All right. You bet. Okay, I have a motion and a second to approve the minutes of the January 28th, 2021 LCRA here meeting minutes with one correction. Any questions from the board? Anyone opposed to approving the minutes? Approved as submitted. All right. Item number 6 is consideration of the finance report for the period of February 1st, 2021 through February 28th, 2021. Jim, you want to give us a brief overview?
Yes, sir, Mr. President, members of the board. It's still early in the year, so it's pretty easy to do the financial report at this point in time. Our operating fund balance stands at $225,254. The taxable fund stands at $3,557,048. User fees collected to date, we've collected approximately $250,000 in permit fees from non-exempt permit holders, which is just under a quarter of the 1.3 million that we expect for this year. So we got a lot of prepayments as usual during January, and then we're getting monthly and quarterly payments coming in through the rest of the year. At this point in time, all of our expenses are more or less where we'd expect to be for this time of year. We haven't really run up any major bills. So at this point in time, I don't see a need for a budget amendment unless, the board chooses to act on the assistant general manager position, at which point in time we will need to come back to amend the budget for that. But at this point in time, as far as expenses go, everything is tracking where we would expect to be for this time of year.
Okay. Any questions from the board? If not, I would entertain a motion to acknowledge receipt of the financial report for the period of February 1st through February 28th, 2021.
So move.
Motion made by Mr. Phil Cook.
Phil Cook.
Do I hear?
Yeah.
Yes. Do I hear a second?
Second, Your Honor. Your Honor, I'm sorry. I had knee replacement and I've been on pills and sometimes I'm not thinking quite right.
That's all right. No problem. No problem. All right. Okay, we've had a motion and a second to acknowledge receipt of the financial report. Any questions from the board? Anyone opposed? Motion carries. The next item is item number 7, consideration of and possible action regarding a proposed board member conflict of interest policy. Jim, did this, it didn't say who generated this policy. I'm sure it came from Natasha, so I don't know who wishes to walk us through it.
Yes, sir, Mr. President. We actually started this process in 2020, and then it's been backburnered and dealt with other issues, but we were hoping to get this taken care of in February when we had a fairly light agenda to get this back in front of y'all. This is the work product of Natasha and Matt, so I will leave it to legal counsel to walk y'all through it and kind of guide that discussion.
Good evening, directors. This is Matt. I want to reiterate, Jim mentioned, some of you may recall we brought this to the board before the pandemic last year. It was an idea that Natasha and I had. It was sort of born out of questions that we received related to conflicts of interest, and we've continued to receive questions on conflicts. So we do think it's advisable to have the entire board on the same page if possible. That said, this draft policy has not been reviewed by a committee, and we haven't had any comments. I think there have been a couple of questions, several months ago. But we wanted to revisit it with the board, see if you all are inclined to ask questions this evening or refer it to a committee or take some other form of action. I am happy to kind of outline it in general, if that would be helpful this evening. Anyone?
Matt, I have this is not a general question, so if you want to wait on this until the general questions are taken care of, I do have a comment on item 6. So if you want to wait till you get to that or deal with it now, at your pleasure.
All right. Well, let me go ahead and provide the general overview, and I will address item 6 when we get there, Director Cook. You'll initially note that we've got a set of definitions at the beginning of the policy. Most of those definitions are based on statute. In item 2 are the statutory conflicts of interest from which those definitions are drafted or derived, I should say. The conflicts identified in section 2 relate to substantial interests in business entities or real property, employment or business relationships with vendors, and then finally gifts, gratuities, and entertainment. We don't have a tremendous amount of latitude in modifying the policy on these particular types of conflicts because they are statutory. The idea here was to hopefully reduce them to something that's more discernible than reading through statutes. I would note that with respect to interests in real property, the statute at issue does not define a substantial interest as including groundwater, but because we're a groundwater district, we thought that was relevant to the consideration, and it's included at this point, but obviously we'd seek board input on that. Item 3 of the draft policy is not based on statute, but is primarily based upon sort of board precedent, what procedures the board has sort of informally utilized in the past, and they relate to participation in proceedings before the board, which happens from time to time. We'll have a director who's involved in litigation, or a director who is employed by someone who's involved in litigation, that sort of thing. And there, the general history has been that the director will abstain and refrain from discussing the matter, and then also seeking legal advice from counsel. Another conflict or potential conflict that's covered under this item 3 is participation in litigation or legislative proceeding involving the district. The idea there is not necessarily a contested permitting matter, but litigation such as a breach of contract action, or maybe an amicus brief that we've submitted in a proceeding to which we're not a party, or potentially during legislative session. If a director has taken an adverse or a position that's different than that of the district, then the idea would be that the director could still vote, but would refrain from seeking legal advice from counsel. Item C concerning organizational conflicts is very similar. And then item 4 is kind of a general provision. And, we have to keep in mind here that conflicts are a difficult subject. And effectively, that provision states that we can't identify every potential conflict that may arise. But generally, if you have a personal or financial interest that could potentially compromise your independence of judgment, or your exercise of responsibilities to the board, then you may be in a conflict situation, and we'd need to look into it further. Director Cook, your question was on paragraph 6.
Yes, at the bottom of the next to the last page.
Yes, sir.
A member who has conflict of interest that prevents discussion or voting on a matter will not be counted for purposes of determining the presence of a quorum with respect to such matter. About this time last year, we had some questions about what constitutes a quorum and how many members. And I think, is it correct that for matters of a quorum, all 10 board members that could be appointed, even if the board only consists of 8 or 9 members, still all 10 members are to be counted in determining a quorum?
Yes, the number that are entitled to serve on the governing body. Yeah.
And as far as voting goes, a majority is also determined by that quorum, in our case of 10 members. So we would need 6 members to vote in affirmation of something for the motion to pass. Is that correct?
So in order to transact action, we would need 6 of the directors to vote in favor of that action. Is that the question?
Yes. Well, it's pertaining to this of a board member who has a conflict of interest, and that would prevent that member from discussing or voting on such a matter. Are those two ideas in conflict, the 10-member quorum and the 6 voting members? Are they in conflict with this in some way, or does it need, or I think at least it needs some clarification and elaboration. So in the future, we'll know how to deal with this situation.
Well, I see what you're pointing out there, and I do think that's a good issue to follow up on.
Okay, fine. We don't need to resolve it, and as far as I'm concerned, not even discuss it at that time, but I would like to see you offer some clarification and elaboration on that.
Yes, sir. Are there any other questions in addition to those that of Director Cook at this time?
Matt?
Yes, sir.
For some reason, I got zoomed out here. I don't know what happened, but I understand the concept of a individual. If there's one person who is not in agreement with the majority of the board on a matter, but what happens if it's 7-3, where 3 members are not in favor? What happens then? I mean,
if you're asking, I think what you're asking about. the
Yeah, if it's a contentious issue, there's a potential of a split being on the board as to which direction we should go. And if it's
So-
go ahead.
Yeah, let's talk about an example there. Say with a legislative matter, the board directs us by a vote of 6-4 to support or oppose a piece of legislation. That would be the position of the board, the majority position. Now, the board members who were in the minority there could still voice their opinion and vote, but the idea is under this policy, they would be restricted from seeking legal advice from the district's council in that matter. It doesn't restrict voting or discussion at all. It's just the difficulty there is it puts the lawyers in a conflict themselves. If we're having to advise a board member on a position that's adverse to the official position of the district.
And I appreciate it because the reason I just bring it because it kind of, the policy address is just potentially just one person, but I don't want to create the perception that it's only going to be just one person.
Yeah.
It becomes the majority rule is what would be the issue to me. And I don't know how you clarify that, but I do know there's going to be an instance where there's going to be more than one who's not in favor of the majority opinion.
I agree. Some clarification would be helpful there.
Okay, thank you.
And again, we're not presenting this for action. We as Jim mentioned, we had included it on the February agenda when the agenda was a little lighter for discussion. We're really looking just for your comments, your questions, and if you want a committee to be involved in helping flesh these things out, then direction on that front. But otherwise, we're not looking for action tonight.
This is not time sensitive, is what you're saying.
Yes, sir.
Okay. So I scanned it, and I think it's a good document. I think it's a good idea, but I have not had a chance to read and cross-reference and think about my position and where I'm at. If I was going to make, it says discuss and take action, I believe, on this item. And if I was going to take any action, I would make a motion that we table this till the next meeting. Give us the opportunity to read through it, spend some time with it, and then come back with some questions and comments. I'll make that motion, Mr. President.
I second.
I have a motion and a second that we table this until the April meeting. And I'd just like to interject that if you have any questions, you might want to direct them to Matt or clarifications. But I would also like to point out some of these things are drawn right out of state law. I mean, there's just there's no room to say yes or no. This is the way the law reads, and we have to apply by it. So,
totally
and
agree.
Matt can tell you that.
Yep.
If you have a question. So,
that's going to be.
With that being said, a motion.
That's going to be my first comment. Anytime I ask Matt, is this in here because you think this is what we ought to do, or what the law says? And if he says it's what the law says,
right,
let's move to the next item. Yeah.
Right. So I have a motion and a second to table this until the April meeting. Any questions from the board? Any opposed to this motion? Motion's approved. Okay. The next item is Consideration and possible action on proposed resolution establishing, authorizing for district office building project, delegating certain authority and responsibilities to the board, the board's building committee, and the district general manager. I know this is something we talked about when the contract was awarded to the architect. So Jim, is this something you want to take off, or Natasha or Matt? Who wants to kick off with this?
I'll go ahead and take the lead on this one. So obviously this is work product from Natasha and Matt, but what we have, what's in front of you tonight is basically a resolution that will lay out decision-making ability for myself, the building committee, and the board. The idea here is that we want to create clear limits of what decisions have to be made at what level as we go through a construction process. So this will lay out, we basically have a series of blanks that need to be filled in by you as board members regarding what in terms of cost or in terms of time delays need to be authorized at different levels. Once we get this done, this document will be very handy for both our architects and for any construction contractors we work with, because they'll understand the decision structure that we're operating under, and they'll know that if there's a fairly significant change in something that may have that impacts cost, they'll know what the response time would be. They can't walk into my office with a $500,000 change and expect an answer that day, because that would be, so the idea here is just to clearly delineate, both for myself, for the building committee, and for you as a board, where those decisions need to be made at, and also to make that clear to any contractors that we're working with as we go through this process. If you flip to the second page of the document, that's pretty much all of the blanks that we would need to fill in if we were going to take action on it tonight. And essentially, it's just laying out percent changes in cost, number of days in construction timelines, and things like that need to be filled in.
Mike, it's Kay Rogers. Can I make a comment?
Sure, go right ahead.
It's really just a matter of form, but for me, since it says, it sort of lays out, it says the responsibilities of the board, the building committee, and the general manager, it would make sense to have section 6 be section 1 and section 5 be section 2, followed by section 1, so that you'd lay out the board's jobs, the committee's jobs, and then the general manager. I just found it really confusing to go all the way through all the general managers' deals, and I'm going, well, wait a minute, how about the board? How about the committee? If I knew what the board was responsible for, what the committee was responsible for, and then what the general manager was responsible for, I think it would read a little more easily.
I agree, Kay. I only would suggest that we reverse that, because normally your manager has a lower threshold than your board. So it should be your board, committee, and then the board. I mean, the general manager, the committee, then the board. Because when it gets to the big dollar amounts, normally is when they come to the board. That's just a thought. But I agree with your concept. It does need to be more in a block. Here's what the general manager does. Here's what the committee does. And here's what the board does.
Well, I disagree. That's how it is laid out. I thought.
Okay, I'm sorry.
Because I'm on the board, I wanted to know, what are we doing, before I had to read through all the things that the general manager is doing. So for me, I just thought it was more clear.
Okay.
Here's what the board does. Here's what the committee does. And then here's we know the general manager's going to do the heavy lifting mostly. But it was just, it's just a thought. And
no, it's fine. I agree with what you're saying. It needs to be clear. I'm in total agreement. Thank you. Any other comments from the board?
Yes, Mike, I have some questions for Jim. And what level of questions do you want? Do you really want to get into nuts and bolts on this, or just more general questions and stuff?
Well, it's how long you want to spend and how long do you want to meet? I mean,
Well, Mike,
it's up
cut
to
me
y'all.
off when you've had enough. Let's just, I won't get into nuts and bolts. If I get long-winded, just say, Phil, that's enough. Let's move on.
All right.
Do we have any idea what the cost of the project is going to be, Jim?
Not at this point in time. We have just gotten the preliminary site. The building committee's meeting tomorrow to review preliminary site layouts from the architect. Once we get that done, then that'll move us into the actual design process, which will lead into the costing. So we're still a ways out from having those total cost estimates.
And how will the project be financed?
At this point in time, we have sufficient money in the bank to essentially run this as a cash project, but that's a determination that we'll have to make once we get the cost back from the architect.
Are we going to have to forego any budget items or limit any budget items that we have in our present and 2021 budgets to pull this off?
At this point, again, we don't have a cost estimate for the building itself. We're still doing the preliminary design work and all of that. So once we have those numbers, then that'll come back to the board for a determination of whether we want to proceed with the project or not. And at that point in time, we'll have to make those evaluations. But again, with the money that we have in the bank, again, depending upon what the cost estimate comes back, we'd have to, if we choose to proceed, we'd have to determine how we want to finance it from there.
I see. How is the general contractor qualifications and the bid for the general contractor going to be determined? Are the architects going to handle that? Is the building committee going to handle it? How's that going to work?
Normally that's done by the architect in the development of the bid specifications.
Okay, and you're expecting the architect to recommend one or two generals to us on that basis?
He'll recommend low bidder in accordance with state law. Well, excuse me, local most qualified bidder.
Lowest responsive bidder.
Response, yeah. Because keep in mind, you can be low bidder, but you may not be the most responsive or the most qualified bidder to handle the project. So,
but the architect will not award the project. The board will award the project.
Board will.
Okay. Will it be the architect that approves payments for completed phases? And, when payments are due for completed phases or phases of the project that are at a certain point, will it be the architect that determines that and approves it for payment?
Normally, on a project of this size, I would imagine every 30 to 45 days, the contractor will make a pay request, and he'll state on there the percentage of work complete to date. The architect will review it and either agree or disagree. And if they disagree, they'll have to work it out. If they agree, they will forward it on to Jim to process for payment. But normally the architect recommends approval, and I just, over the years with the projects I've worked on, I just caution that you watch those recommendations very carefully, because sometimes they get a little easy on the contractor.
You're exactly right. But what you said is exactly right. The pay request will come in, the architect will verify it. If the architect agrees, he'll send us a recommendation to pay based on the correct pay request. And the architect better do his job and make sure we're paying more than what we have done in case that contractor goes belly up. But it will be bonded, so we'll be protected with a bond, a performance
So
bond.
The architect essentially will act as our inspector for the project in terms of quality and work materials and all of that kind of stuff.
Yeah,
that would have to be determined in the contract with the architect. I don't know if we were going to hire him for RPR services or whether we're going to inspect it ourselves. or get a third party inspector. He won't inspect it unless we pay him to inspect it.
Yeah, we talked about that at the building committee meetings.
I'm sorry, I didn't hear your comment.
I said at our prior building committee meetings, we discussed hiring our own inspector.
Good.
This is Matt. I'll just comment.
But it has not been finalized.
This is Matt. I'll just add that.
Pardon?
This is Matt. I'll just add that there are some limited inspection scope of services within the architect's contract, but we haven't engaged, as Director Fleming was referencing, the RPR services.
Right.
And the idea was we would, once construction began, engage an independent third-party inspection firm to provide those services.
That's a great idea, by the way.
I have some other questions, but I see that I'm getting ahead of the project and I'm putting the cart before the horse. So that's all I want to say about it at this time.
And Director Cook, if you don't have a copy of the contract, just let me know and we'll send you another copy of it. That way you can see the contract that we have with Negrete and Kohler, and you can see the services that they've already committed to. And that,
Jim, I may well have a copy of that, but it may well have slipped my mind too.
We can send
I
you
will
another
look
copy.
for it though. Thank you.
Yeah, we'll send you another copy tomorrow. No problem.
Thank you.
The only other question I have is this going to be our overall policy for all projects or just for the building committee, for the building project, excuse me?
So the document that's in front of you tonight is strictly focused on the building. So this
Okay.
is just laying out how we're going to proceed with the decision points in the building process. This doesn't pertain to
That answers
anything.
all my.
Yeah.
Okay, that answers my questions. Okay.
If I may make a suggestion, President Talbot and Jim, in light of Director Rogers' comments, it might be a good idea for the building committee the next time they meet to look at those items on page 2 that Jim was talking about, and maybe we fill in those blanks and recommend them to the board at the next meeting. And at the same time, I can revise the form to reflect the structural changes that Ms. Rogers not recommended, but suggested earlier this evening.
And Matt, we can certainly go that route, although the reason that we brought this with the blanks to the board originally is we didn't want the perception of the budget committee writing its own check in terms of.
Oh, I apologize.
Where those limits. Yep, but if the board's comfortable with us taking that approach, we can certainly do that. But at the time that this was drafted and originally contemplated, we didn't want the building committee to come in and having already established those. But if the board is comfortable with us coming back with recommendations from the committee, that'll certainly make this faster and easier for us.
I think the building committee is where it should go. So
I agree.
I would just say we take no action tonight pending review by the committee and bringing it back to us. With the understanding that this project is going to start getting on the fast track now. So, I mean, we don't have a lot of time, but to provide you time to fill in the blanks and make some structural changes and get it back to the board.
Well, we have
the
building committee is meeting tomorrow, so we can do that and get it back to y'all by next month.
Okay. I have a motion second that the building committee review this and make any other suggested changes other than what's been discussed tonight. Any questions from the board? Anyone opposed? Motion carries. Okay. Discussion and possible action on hiring an assistant district general manager. This was something that was discussed during the budget process and is being brought back for reconsideration. So Jim, I'll turn it over to you and let you outline what you see this person doing for the district and the board.
Thank you, Mr. President, members of the board. This did come up during the budgeting process back in December. We had some further discussions about the position in January, and again in February. We had intended again for this to be on the February agenda meeting agenda. Essentially, the job position that's laid out in your board packet, I kind of tried to take as broad approach as I could in describing the position, the responsibilities. It's the advice from members of the budget committee. I did strip out some of the financial related information just from a perspective of process control, making sure that we limit signature authority and things like that. But essentially, with the work that's currently going on in the district, with the potential for this building coming online, with our expanding monitoring, it's time for us to expand and bring on someone else to help take care of that field work, or also to help us get a little bit better representation both at the regional planning water level. Currently, I sit on Region K's board, but we don't have anybody that's at the Region G meetings on a regular basis. So an assistant would help cover Region G water planning for us as well. So the description, like I said, is taken in a fairly broad brush in terms of responsibilities. And at this point in time, I think we're at a point where we need to expand and add an extra pair of hands for the district. The position itself is basically someone that can fill in for me when I'm not around, someone that can carry out some of the field work, and that way we can have people working in both counties at the same time if need be. But really, I'd be happy to answer any questions y'all may have about the posting. We have gotten some more feedback from the budget committee members about possible changes in language and structuring. So my recommendation tonight, if you do want to take action on it, would be to give approval for posting with some minor modifications to the job posting before it goes up, based on feedback from the budget committee or feedback from board members tonight.
Okay. I will open this to discussion. Any board members have a question of the general manager?
Jim, is this your recommendation?
I'm sorry, sir?
Is this your recommendation? And one thing okay, go ahead. Answer that first.
Yes, sir. I think we're in a place where we need another set of hands, especially in the field.
Oh, I understand that. I'm just talking about the job identification. I mean, is this what you're recommending that this person do?
Yes, sir. Like I said, I took the original general manager's job posting, trimmed out some duties that they didn't need, and then just converted everything else to either assist in or act in the absence of. So that would be my recommendation. Yes, sir.
Okay. Well, there's one thing in it talking about the schools and public relations and so forth.
Yes, sir.
Does that maintain the person that we have doing this under the assistant, or does it put those duties to the assistant?
At this point in time, I don't see that. I would see that as a supplement to our existing education program. I would not see this as necessarily replacing Kathy Baker at this point in time. If we wanted to make that change down the road, we can certainly address that, but I wouldn't dump anybody directly into the school their first month on the job.
Well, I was just wondering, if Kathy would be under this person, or because of the way it's set up in the job description, or under you.
I she would remain underneath me at this point in time.
Okay. Well, then I think maybe that needs to be looked at.
Okay.
Okay.
Jim, what salary range are you anticipating offering for this position?
We kind of went back and forth on that in the budget committee, and somewhere starting, and I apologize, it's been a while since we actually discussed the numbers. I want to say it was in the $50,000 to $65,000 range.
Okay. I'm in favor of doing this. I do have a couple of concerns. When we talk about building the new office building, it's sort of a one-off item. We have the money for that. How are we going to pay for this position? What are we going to have to give up in lieu to pay this salary on a yearly basis? And what sources of income are we going to be dependent upon to pay that salary?
You're absolutely right. We will have to evaluate our budget and figure out how to reshape the budget to create a space for it. In the initial year, the money would more or less come out of text pool just to keep the budget balanced. Going forward into 2022, we would have to look at the budget and figure out where we can shift money around to support that. Off the top of my head, our legal line item, depending upon the year, some years we become very close to using the full legal line item, and other years we don't. So there may be some wiggle room there, but that's something that the budget committee would have to evaluate once we do make a permanent hire. Okay,
and I ask that you see that this gets done in an explanation of where the salary is going to come from over time. I would like to know that if we are going to become dependent on a certain source or sources of income, or if we're going to have to, or if we're going to have to cut budget items. I would like to know that up front. And again, I believe we need this position. I really do, and I want to see it work. The other consideration I have, and I don't mean to hold this hiring an assistant manager hostage to this in any way, but I would like to see employees evaluated in a less general way than they are now. In other words, according to our rules, you are to be evaluated by the full board once a year. I would like to see that happen and sort of work that into this process. In terms of, I'd like to know, I'm not questioning you what you do, but I would like to know what you do. And sort of on a monthly basis or a sometime basis like that, if you could just describe what you do on a week-to-week or month-to-month basis and how much time you put into it. And I would like to see you evaluate your staff sort of on that same basis. Now, I'm not saying we have to have all of this done before we hire the manager, but I would like that to become part of our process and perhaps discuss a little more concretely as we get closer to hiring someone, what his specific duties would be, and try to assign some times allotted for those duties.
I think that's a reasonable approach, and that's something we can certainly look into.
And we will get implemented for the fourth quarter evaluations. Normally, you do evaluations in the fourth quarter in your budget preparation process. And that will be done when we move into the fourth quarter with the appropriate forms. So any other questions? I think with the questions that have been asked, Jim, I would suggest we don't take any action on this tonight, for you to make the changes and to do your budget analysis unless you think you can have it done by the next meeting.
I'll have to schedule a meeting with the budget committee to go through and work those numbers out, but we can try and get it done for the next meeting, absolutely.
Okay, well, then we'll place this on next, I'll entertain a motion to table this until next month.
So move.
Okay,
Second.
I have motion second to postpone till the April meeting, the creation of an assistant general manager. Any questions from the board? Anyone opposed?
I'm opposed.
One opposed. Okay. Any other opposed? With one opposed, the motion carries. Okay. The next item is consideration of and possible action regarding the request of Gatehouse Water LLC for no increase amendment to special condition number 8 of operating permits for the district wells number 5933122, 5933123, 5933217, 5933409, 5933410, 5933411, 5933412, 5933413, 5933504, and 5933505 from the Simsboro Aquifer located in Lee County. Gatehouse permits, Gatehouse amended request, Gatehouse Water LLC submission to demonstrate compliance with special condition number 8 of the Gatehouse permits, and Gatehouse Permit Water LLC request to modify the 2016 monitoring network, 2016 monitoring well agreement applicable to the Gatehouse permits to address certain district monitoring network issues raised by the district board. Are there any representatives from Gatehouse here this evening?
Good evening, Mr. Talbot. This is Ed McCarthy. I'm counsel for Gatehouse and representing them.
Okay.
My managers would normally be here, but I've got one on spring break and one with a family illness that's very severe. So they're not here. But our project engineer, Steve Coleman, I believe, is on the line. He was here earlier.
Okay. Do you like anything you'd like to say to the board, address the board on?
Briefly, Mr. Talbot, if I could, first I want to wish everybody a happy St. Patrick's Day. I hope you're all wearing green. Appreciate the opportunity to visit with you again tonight. In January, we reviewed each of these items and we discussed in some detail our requests. With respect to special condition 8, there are two things. First is the amendment, and the amendment was made at a time prior to our submission of a contract and satisfaction of that special condition. And we had requested the no increase in the production authorization amendment with two alternative recommended changes to special condition 8. One was to extend the time period in it for a 4-year period. So that would provide Gatehouse, I believe, with a full 5-year period opportunity from the time they secured these permits back in 2020. The second alternative was to remove the time constraint in special condition 8, but impose a requirement that prior to production that we provide the district with evidence of the contract or the agreement between Gatehouse and the parties they would be delivering water to, so that the general manager could confirm that the water would be being placed to a beneficial use. Since we initially filed that amendment request, we did file a contract in January with the board prior to the deadline with the Central Texas Water Supply Corporation. I believe that contract satisfies the requirement of special condition 8. So our preference, one is we would request a confirmation from the board to that effect so that we could move forward with efforts to develop the project and develop the monitor well system, knowing that we had the permit as issued based upon compliance with Special Condition 8, but we are not withdrawing the amendment request other than to modify it to request that Special Condition 8 be modified to include the provision I mentioned that would require we constantly keep the district and board up to date on the agreement we had so that the general manager could monitor and ensure that beneficial use of the water was being made in accordance with Chapter 36 and the district's enabling legislation. And then the third agenda item that we explained in January was we have been monitoring, of course, the board's discussions with respect to monitor wells and concerns that had been raised. And the monitor well agreement is not an agreement that Gatehouse had prepared or participated in the development of. It's one we inherited from Four Star. And that's not a criticism of it. It's just a factual observation to let you know why this came about. Again, based upon our monitoring of the expressed concerns of board members and members of the public, we had discussions with your general manager, Jim Totten, and Natasha Martin, your general counsel. I don't think Matt participated in those. He may have. We have multiple conversations, but we talked about the monitor well agreement. And in 2016, when the monitor well agreement was first put on the table and entered into, the idea was to facilitate the district's ability to monitor the impacts of the Four Star project directly. And what we've been hearing in the board meetings and what we discussed with Jim and Natasha was the idea that we needed to modify that agreement so it wasn't focused just on what the Four Star, I'm going to call it the Four Star project, now the Gatehouse project, impacts or effects, if any, on the aquifer, but to better integrate and incorporate our monitor well system into the overall district monitor well system, and to monitor not just Simsboro production and what was going on in the Simsboro aquifer, but to look at the adjacent aquifers and in consultation with the district's general manager and hydrogeologic consultant, Andy Donnelly, to identify whether the district would prefer we put wells in an upper, one or more upper found formations, so we could evaluate potential communication between production from the Simsboro, from the project, and some of the upper aquifers like the Hooper and things like that. And clarify that point. Mr. Cook, in one of the meetings last fall, had raised some concerns about who had final say and who was really controlling that monitor well agreement. And so we had also suggested language changes that made it clear that, one, that this was a cooperative, coordinated effort between the permittee and the district, but that and decisions on locations and things would be something that would be worked out between the two, but that the district overall retained control of the monitor well system so that we could ensure that our contribution to the monitor well system was integrated with the district's overall system and had the greater good in mind with respect to the entirety of the district. So that was the basis of the request to amend the 2016 monitor well agreement. And the other clarification in that was the possibility, and again, this is something that would have to be coordinated closely, particularly with Mr. Totten, because of his knowledge of the area and the technology capabilities, was the possibility, we have a specified number of wells to be included with the monitor well agreement. And the cost to drill a new well is substantially higher than the cost to retrofit an existing well. And so we had suggested the possibility of, if the district approved it, we might be able to take the investment that would be the equivalent of a single monitor well and go in and retrofit multiple wells to add even greater coverage for the monitor well system than just the expressly stated number of wells in the agreement.
Okay. Does any of the board members have any questions of Mr. McCartney? Any questions? Okay. Mr. Box, would you like to address the board on this item?
Excuse me, I wasn't quite ready. No, I think I'll
Okay.
not comment on this at this time. Thank you.
Okay. All right. Mr. Weir?
Thank you, Mr. Chairman. I did not sign up for this agenda item.
Okay, well, it was on my list. I'm just doing what they give me. Okay. All right. So, no.
Michelle Gangus is registered for this topic.
Yes. Michelle, thank you.
Yes, sir. Thank you. I was just about to interrupt you, but I didn't want to.
That's fine.
Thank
Always
you.
interrupt. Feel free to.
Okay. Okay. I'll be as brief as possible, but I want to be clear. I'm speaking for myself tonight as a Lee County landowner and not for the Simsboro Aquifer Water Defense Fund. However, at any point, there's an offer to monitor other formations and broaden the monitoring program. The SAWDF certainly supports that. I suspect you're going to be told tonight, to quote Mr. Weir's way of saying it in his comments, that your hands are once again tied on this gatehouse water permit. In January, I feel sure you were told you had no choice but to extend the export permit. The Texas Water Code did not require that result under a literal, not interpretive reading of the relevant section. And moving a little dirt with a bulldozer and calling it a pipeline was not reasonable as a way to avoid that literal reading of the water code on a matter this important. Now you may be told there's nothing you can do to enforce Special Condition 8 of the Gatehouse Water Operating Permits. It won't be the first time you've been advised to give ground on your permits, and it may not be the last. But I can't help but notice the advisors who give you that advice are the same counselors you depend on to write your non-exempt permits in the first place. I'll end by saying I just hope you might find ways to do a little better up front in drafting your permits. Well, but I do want to add one thing. In the alternative, I believe you do have grounds to say no to Gatehouse Water and reduce the permit to zero. So why not try that approach and stick up for your primary constituents of this district just this one time, see what happens. I appreciate being able to speak to you. Thank you.
Thank you, Michelle. Okay, I think we got everyone covered on that item. I assume the board wishes to go into executive session to discuss this with legal counsel.
Yes.
Okay. In
Please.
accord, at 8:25, the board will adjourn into executive session to consult with its attorney regarding item number 10 of the agenda, a request of Gatehouse Water LLC for a no increase amendment to special conditions number 8 of the operating permits for District Wells number 5933122, 5933123, 5933214, 5933409, 5933410, 5933411, 5933412, 5933413, 5933504, and 5933505 from the Simsboro Aquifer located in Lee County, Gatehouse permit, Gatehouse amended request, Gatehouse Water LLC submission to demonstrate compliance with special condition number 8 of the Gatehouse permit, and Gatehouse Water LLC request to modify the 2016 monitoring well agreement applicable to the Gatehouse permit to address certain districts monitoring network issues raised by the district board. The board will now adjourn into executive session. I guess, Natasha, you'll break us in.
Like, we have about a 5-minute break.
Sure.
We have about a 5-minute break. Thank you.
I'll start the breakout rooms and then we can start up in 5 minutes.
Miss Natasha?
Yes.
Mr. Sherrill, how you doing?
I'm good, Mr. Sherrill.
Just want to make sure that you can see and hear me.
Yes, I can. And everyone will receive an invite to the breakout room. Just a moment.
And is there any action or motion from the board? David, I think you're muted.
Natasha, I would like to know what your recommendation is.
Hold on, Director Fleming. I'm letting in Director Shoddy. Let me get that done first.
Yeah, don't leave Larry out.
Okay, and it looks like Director Rogers was also in the waiting room. Director Rogers, are you at 5912?
I am. I fell down the rabbit hole. I ended up in the main meeting.
Okay. Well, everyone's
we
back
all are.
in
We
the
all did.
meeting.
Oh, okay.
Okay.
We ran out of time for breakout.
Yes, everyone is where they need to be now. Okay, Director Fleming, my recommendation would be to leave the suspension in place and direct legal counsel to present the board with amendments to the operating permits and the monitoring well agreement as discussed in executive session at the April board meeting.
For discussion at the April board meeting.
For consideration and discussion at the April board meeting. Consideration and action.
So moved. So moved.
Second.
I have a motion by Board Member Fleming and a second by Board Member Cook. Is there any discussion from the board? Anyone opposed? Motion carries. Thank you.
Thank you.
The next item is item number 10, discussion and possible action to provide guidance to the district general manager and district hydrologist on the proposed desired future conditions, DFCs, being considered by the Groundwater Management Area 12. Jim, you want to make a presentation on the board? And I assume Mr. Weir and Mr. Box will make a comment after Mr. Totten's presentation.
So, Mr. President, I'm going to start off by having our hydrologist kind of get the board up to speed on the timeline that we're looking at for the DFC process. We're in the very tail end of the DFC process for this cycle. So I want Andy to give you all kind of a calendar of what we're looking at going forward. And then once he's done, I want to speak to you specifically about an issue that's come up at GMA 12 regarding some modifications to the pumping file that has been proposed by Post Oak Savannah, and get your guidance on that for our meeting tomorrow. But in the meantime, we can either take comments before Andy's presentation, or we can take comments after we're done hearing from the staff, whichever way works better for y'all.
Okay. I'm just trying to accommodate the public. When would you like to make your comments, Mr. Weir or Mr. Box, before or after?
This is Steve Box. I'd prefer that we make our comments afterwards. Thank you.
Okay. Go ahead, Jim.
Andy, if you want to go ahead and lead off, Phil, with the calendar that we're looking at.
Yeah. Can everyone hear me?
Yes.
Yeah.
Okay, good. The timeline we reviewed a few times has kind of been in flux over the last couple of months. We were initially planning on discussing the model simulations and finalizing proposed DFCs in early February. And then in February and March, the districts were going to come back and discuss and approve the proposed DFCs. And then in April, the GMA was going to formally adopt the proposed DFCs for review by the GCDs and submit that to the board. At that point, the the comment period would start, and then we would move into hearings and adoption of the final DFCs. However, with kind of some recent things that have been going on within the GMA, we haven't gotten to the point of finalizing proposed DFCs, where that's still in discussion. We have the board meeting that we are having this evening, and then we have a GMA 12 meeting tomorrow morning, at which point we will continue to discuss model simulations and proposed DFCs. And then we only have one more board meeting, our April board meeting, before our May 1st deadline for the GMA to submit proposed DFCs. So we are out of time. We need to get this done. We will probably have, we'll certainly have the GMA meeting tomorrow. We will have, depending on how things go, I would imagine 1 or 2 GMA meetings in April, the second of which will need to have the GMA formally adopt proposed DFCs for submittal to the Water Development Board. And that's kind of where we stand.
So as Andy mentioned, we are running out of time on this DFC cycle. We lost a lot of time waiting for the new GAM to be finalized. Once we got the new GAM, we did the GMA did a lot of testing and evaluations of the GAM, and then that just kind of put us behind in the entire process. Throughout this, we worked with the DFC committee on the numbers that were coming out of the planning process. We presented those numbers to you as the board several times in the past 2 years. And so, we'll be bringing those back to you again. But what has come up lately, this started in January. Post Oak Savannah has proposed modifying the pumping files that we use for the simulations. It came up between, I believe it was just after our January board meeting. So I spoke with the DFC committee. We kind of talked through the process and went into the GMA meeting in January based on the advice of the DFC committee. And what Post Oak Savannah has been proposing is they want to reduce production, modeled production in the Carrizo aquifer, which essentially from the current model level is 15,000 acre feet per year. They want to reduce that down to 12,000 acre feet per year in the model. Historically, in the GMA process, whenever we've developed pumping files, we include all of the current existing pumping and then simulate any future pumping that may be coming online based on permits. The difference here is that the 15,000 acre feet that was in the pumping file is permitted production associated with Vista Ridge, and the reduction they were seeking to 12,000 acre feet was a reduction of existing production, not a reduction of potential future production. Based on that, after talking with the DFC committee, the motion was put forward at the GMA meeting and was voted down by three of the five, or I believe 4 of the 5 members of the GMA. The matter came back up at the February meeting and was tabled, and we brought up again at the meeting tomorrow. Because of the timing of GMA meetings versus our district board meetings, this is the first time I've had the opportunity to bring the question to the full board, knowing that the issue is going to be brought back up. So my concern in up to this point in time has been that this reduction in production in the pumping file is a deviation from what we've done in previous GMA processes. I don't necessarily oppose the idea, but I don't think that changing the process this late in the cycle is a good idea. I think it could be picked back. We can make this change at the start of the next planning cycle when all the stakeholders can be involved and provide comments as we work through that. And that's been kind of the basis, for my opposition to changing that. The end result of making that change is that absent a mechanism to enforce that reduction to 12,000 acre feet, we're going to have more physical drawdown within the district than what the models are predicting or what the DFCs would predict. And so I was very reluctant to make a change without knowing that there was something on the ground to match that reduction especially at least during the next 5 years of the planning cycle. So basically what I'm bringing to tonight is I'd like to have a discussion of that issue. And if you're comfortable with us continuing on the path we've been going, then no action needed. If you'd like me to change my position and support Post Oak Savannah's recommendation to reduce that production in the model, then we can do that through board action.
Does any of the board members have a comment or make a recommendation to Jim?
Jim, as we discussed in the DSC committee meeting, I support you on your reluctance to change the DFCs if that's what you believe is the correct thing to do.
And I agreed with that too.
Yeah, your presentation in the DFC committee was very strong, very understandable, and your position on that was very clear, and I support you on it. So if you don't need any action, unless somebody else does not support you on that, we can discuss that. But if you don't need any action, I'm willing to say move forward with what you and Andy think is best for the district.
Same here, based upon what you presented to us at that meeting.
Are there questions from the other board members?
Mr. Totten?
Yes, sir.
I like what you do. I like what you say. I put a lot of stock in what you say and you do. And please continue on. Thank you.
So Jim, what I'm hearing is you're recommending no modifications in the existing DFCs?
What I'm recommending is that we don't make a change to the methods that we have used for developing the pumping files for developing DFCs.
Which would result in no modifications?
So the end result of what they have, of the Post Oak Savannah suggestion is an increase, is approximately 18 feet less of drawdown in the Carrizo over a 50-year timeline. Now, again, I support Post Oak. Post Oak has made the argument that it's their right to manage the aquifer as they see fit, and if they want to reduce that production, they have that right, and I agree. The issue that I have is that for the past three DFC cycles, we have always included full production in the model and then had hypothetical production based on permitting going forward. I don't like the idea of making the change in that process this late in the cycle. And so I would prefer us to proceed with the pumping files that we've developed where we're not making material changes to existing pumping that's ongoing. And if we need to make a change to how we're going to simulate pumping files for the next DFC cycle, then I think that's a great discussion to have. I'm just not comfortable with a major procedural change this late in the cycle.
Was any discussion given to the fact that there are wells going dry in Lee County because of Vista Ridge pumping? And was that in any way factored in to the DFC process?
So at this point in time, the change that they're proposing, the 18 feet fewer 18 feet of less drawdown over a 50-year timeline, that doesn't change the impacts that have already occurred. That's the difference between, I can't recall the number off the top of my head, but those impacts have already occurred, and that's going to occur regardless of what changes we make to that pumping file right now. This is about simulating what's going on in the future, and so the question of property rights and the question of impacts of pumping from Vista Ridge, that can definitely be part of the DSC discussion that we have. But when we're talking about changes to the pumping file that we're going to use to predict DFCs, it's a question of process that we build in all of our existing pumping that we know, and then we guess about what pumping is going to do in the future. And this is a reduction to pumping that we know is occurring on the ground, at this point. And that's the procedural concern that I have. Like I say, I'm more than willing to have that discussion on changing that in the next cycle. But for this cycle, as Andy has pointed out, we're late in the cycle, and that's a major procedural change that requires a lot of stakeholder input to try and change how we've handled developing pumping files.
Yeah, okay. Does Post Oak Savannah acknowledge or recognize the fact that Vista Ridge pumping is causing drawdowns in wells in Lee County to dry up?
I am sure that they are aware of that. Yes, sir.
And have they proposed at GMA 12 level any recommendations or any way to remedy that situation or address it?
That has not been a discussion at the GMA level, no, sir.
But it has been a discussion in our district.
Yes, sir.
I'm glad to hear that. And I know it has been, yeah.
Yes, sir.
Yeah, I mean, we had a really good discussion, yesterday about it. And the board will be hearing about that discussion soon.
I'm glad to hear that. I would like to know just a summary of that discussion in some way.
Oh,
Dave.
yeah, no problem. And
Good.
Jim, stop me if you want to, but we're talking about earmarking a significant amount of money to take care of our Lee County customers or residents that have already experienced issues with their pumps and their levels. Is that fair to say, Jim?
That'll be part of my general manager's report at the end of the meeting. So.
Oh, well, there you go. Sorry, I didn't mean to steal your thunder.
Good deal.
Not at all. Not at all.
So if you want a motion, I will make a motion that you move forward with your recommendations, yours and Andy's recommendations, and just move forward in the direction that you're going. And this is something that at this late date in the DFC process, and we can revisit this when the new 5-year process starts.
The takeaway this year, and we've gotten a lot of good feedback from stakeholders. We've gotten a lot of good information that's come in just in the past several months. And it's all great. It's great material, but we're still late in the process. It's gonna be hard to incorporate any of it. The key, I think, is to, bear in mind that literally the day after the DFCs are finalized, we restart the entire process.
You bet. You bet. I'll make that motion, Mr. President, if you want it. If you don't, that's fine.
No, if we could just hold it for a moment.
I'll second it.
Okay, we have a motion and a second, but before we take action on that, I have had a request for 2 individuals to speak to the board on this issue. Mr. Box, if you'd like to address the board on this issue at this time, please do.
Yes, I'd like to address the board on a little broader basis, but because I didn't realize that this item is really more restricted to this particular situation that's going on in 2012. But as a preliminary statement, I'd say that the environmental stewardship is also hesitant to see any numbers changed in the files that that are contrary to what we know to be true. That being said, the DFCs that get adopted don't particularly have to be made from that same GAM run. There is some latitude with respect to how one goes forward protecting the DFCs and those situations. And I think the fact that we have this situation in the Carrizo aquifer that is stretching into our Lee County here is a very good example of some other things that are going on in the GMA 12 that seem to keep coming up. And basically what that is, and I've sent you, I've given you all a couple of pages of notes that are statement that both Environmental Stewardship and SODF have put together in a joint statement on this. And I'd like to just open up with the fact that the first paragraph, that the districts of the GMA 12 have consistently taken policy positions that protect the sustainability of previously issued permits that have been granted rather than to protect the sustainability and the reliability of the aquifers. And this approach results in managed depletion or mining of the aquifers. And what I'd like the board to understand, and some of you do realize, is if we go back 13 years when we first started this process, the board was in Lost Pines was very much on the side of wanting to have a sustainable aquifers, and 50 foot of drawdown sounded like an extreme amount of drawdown at that time. Since then, this continuous process of eroding away and supporting the sustainability of the permits that have been granted continues to bring up issues like this one that we're seeing with the landowner situation. And I'm going to let Andy Weir comment to that a little bit more. But the other things that are coming up are kind of for the same type of reason. They're in going through the 9 considerations. Whenever we consider the impact on surface waters, for example, what we find is that we don't have enough information. We don't have enough data to make a good, solid judgment. On the other hand, the information that we have tells us we have the potential for some very serious problems. And on that basis, during the last round, what the GMA 12 decided to do was to readopt the last round of DFCs while we got the data and the information. Well, here a year later, or actually 5 years later, we come to the point where we have improved the GAM to be able to look at surface water impacts. We've done
15 seconds.
Deal. Excuse me? Am I out of time? Anyhow, so the bottom line is I think that we need to readopt the DFCs that we have and provide ourselves with enough time to get the data and the information that we need to resolve these issues. And this is just one example of how these issues are blowing up and causing, we need to deal with them before we move on. Thank you. I appreciate the opportunity.
Thank you, Steve. Mr. Weir?
Yeah, I'm gonna share my screen with y'all. So these are the numbers that are being proposed that are based on the GAM 2020 and the pumping files that Jim and Andy talked about. And so you'll see that the numbers are quite significant. And I'm going to focus on the Carrizo because I have a lot of specific data that deals with the Carrizo. But you're almost doubling the drawdown in the Carrizo with these numbers from this pumping file. And you see the Simsboro is going down another 100 feet. And so those are key areas. But something I showed the GMA 12 back in February meeting was you can calculate the number of Carrizo wells in the district. And with the well data information that we have, you can get a really good idea of the maximum depth that you can put a pump in each of those wells. And based on that, you can figure out what the maximum drawdown is in that well before that starts sucking air or before it's just totally unable to be usable anymore. You can't drop the pump any lower. So I did those calculations. I used the data file that I got from Jim Totten, and I used the geographic information system. That's the same stuff that Andy uses and Steve Young, all the hydrologists use with the mod flow and all the cells. And so best calculated, we've got about 228 Carrizo wells in the district. Well, if you go with the bottom numbers there, if you go with the suggested drawdown of 139 feet, that 124% increase, you're looking at having 19 wells that are going to have to be re-drilled because they wouldn't be able to get any water. And you're going to have to mitigate up to 200 wells. If those drawdown numbers. Now, the current DFC, which is 62 feet, you're not going to have to re-drill any wells, and you're going to mitigate significantly less number of wells. So you have the joint statement from SAWDEF and from Environmental Stewardship saying we really should readopt the current DFCs because due diligence just hasn't been able to be done. So if we know that about those wells, we can look at the socioeconomic impact. And here I'm going to focus on those cases that we have from SAWDEF. 14 home landowners contacted us about their wells going dry. You heard from 2 of them tonight at the opening public comments. So these are their wells. These are the 14 wells that went dry, and some of them have 2 wells on their property. So we looked at 16 cases. And here is just, I looked up those properties on the Lee County Appraisal District site, and here it gives you an example. So most of those were farm or rural livestock operations. So without water, those property values, the value of that is next to nil. So you're looking at potentially damaging, just in those 16 wells, $7 million worth of value. Now you've got 200 wells in the district. So multiply that by 200. You're looking at over $1 billion worth of value that you will be impacting with the DFCs that you adopt. So we encourage you to readopt the current DFCs. Let the process go, as Jim stated, but you have you can say, we don't have the full socioeconomic impact. We don't have all the answers to the hydrology that we need for surface water, but we do have negative trends. So we know we need to be careful there. You have enough information to say we have a reason for readopting our current DFCs, and we will improve that process. So thank you all very much.
Thank you. Okay. You've heard from Mr. Weir and Mr. Box. The board does have a motion and a second to accept the recommendation of the general manager regarding using the existing file data at GM.
Mr. President, can I verify the second?
Yes.
Who seconded my motion?
I didn't.
Was it Phil?
I did.
So Billy should.
No,
I seconded.
Okay, Phil seconded it.
Okay.
Peggy, motion, Phil second.
Okay. All right.
Thank you.
Any other questions from the board? Anyone opposed to the motion? Motion carries. We are now at the general manager's report.
And Mr. President, and members of the board and members of the public, just to be clear, the next steps in the process will be adoption of a preliminary DFC, at which point in time that comes back to the district for consideration. Then there's public hearings. So this is by no means are we at the very end of the process. We still have a lot of time for stakeholder input at the local level. So, right now we're just trying to get the model finalized so that we can get to that next step. And one recommendation I will make at the start of the next DFC cycle is that we set a calendar at the beginning of the cycle that locks the pumping file of a particular, say 2.5 years in. So that way we have the pumping file finalized and we don't run into these problems in the future with last minute tweaks and changes that cause all the other districts to have to go back and rebalance. So hopefully this will be the last time that this comes up. Okay, the general manager's report for the reporting period of February of 2021. I think for the first time that I can remember, we had 2 wells drilled within the district, 2 new wells that were drilled. I think the Freeze probably did a good job of tamping down on drilling activity, but only 2 new wells were drilled in both actually in Lee County this time. I'm sorry, I got to pull my agenda up again. I'll skip to the big one. So the budget committee did meet yesterday. This has been part of an ongoing discussion that we've been having since January. At the meeting, we did finalize, or the budget committee approved a draft proposal for how to handle a mitigation fund for Carrizo wells that are located in Northeast Lee County. We're making some final revisions to that draft, and we hope to bring that to you at the April meeting for your consideration and hopeful action on. We are looking at setting aside a fairly large chunk of the money that we have in tax pool to provide for mitigation, mitigation costs to the residents that are being impacted up in Northeast Lee County. We'll have those details ready for you. I hope again for next month's meeting. The legislative committee meeting also met yesterday. We reviewed all the bills that have been filed with the bill filing deadline having closed on Friday. Those bills have, I'm in the process of working up a priority list of the bills that we're most interested in and the bills something that we need to focus on based on the feedback from the legislative committee. I know Greg is here, so he can give you much more information on that. I won't take up much time on that. But once we get that list, the bill priority list developed, we'll get that out to the board. We'll get that up on the district website, and we'll keep that up to date so that you as board members and members of the public can see what bills we're tracking and what actions we're taking. I can say that this session looks like we've gotten off lucky. There were only a couple of bills that I would describe as odious. The rest of them were, some range from, like Mr. Weir pointed out, the sustainable groundwater modeling, which is a great bill. And then some of them, like I say, we only had a couple that were just absolutely bad, in my opinion. So we'll get that up to the website and out to you as board members as well. And I won't take up much more time on that since we do have Greg here. The last thing that I will point out is the building committee is meeting tomorrow afternoon. We have received 4 preliminary site layouts from the architect. They've completed their initial site assessments, and they need us to begin picking a preliminary site layout so that they can finalize traffic studies and some other details that they're still lacking from the initial site assessment. But they have determined it's a good site for us to build on, so we're going to start moving forward on site layouts, and then from there move into the design phase. And as we talked about earlier, once we get that done, we'll have a better estimate of cost, and we can make a decision about whether or not to proceed with this project. As far as upcoming meetings go, we have GMA 12, as it's been mentioned. GMA 12 is tomorrow morning at 10 a.m. That's a virtual meeting. The link for that will be on our website. If it's not there now, it'll be there as soon as we get done here tonight. And Region K, I don't believe is going to meet until after our next board meeting. So I'll update you on that meeting date and time at the April meeting. And with that, I'd be happy to answer any questions you may have.
Thank you, Jim. Appreciate you've been rather busy this last month. I appreciate all your efforts. Item 13, discussion of Lost Pines Groundwater Conservation District legislation, related legislation, and or activities occurring that affect or pertain to the district and groundwater. I saw earlier that Mr. Ellis was plugged in. I don't know if he's still with us or not.
I'm here.
All right, Greg, take it away.
I'm sure, as everyone already knows, this has been a crazy session. There's about a third of the members of the legislature now that are pretty much operating in business as usual. You can walk up, knock on the door, walk in, have a conversation with their staff. There's about a third that require appointments. They will only allow people in the office by appointment. And there's about a third that don't have any meetings at all. They will only meet via Zoom or some other remote method. That has made the job of trying to keep the membership apprised of issues much more difficult than it's ever been in the past. It's difficult at best to get members on the phone and to get scheduled meetings because they're busy in committee hearings and other things. Interestingly, the water committees have not really met. In fact, the Senate committee hasn't met at all. The Senate Water, Agriculture, and Rural Affairs Committee has not yet met this session. The House Natural Resources Committee meeting has had one meeting last Monday, a week ago Monday, and only had invited testimony from TCEQ and the Water Development Board. I expect both committees to meet this coming Monday and Tuesday. The Senate committee is scheduled to meet regularly at 8 a.m. on Mondays, the House committee at 8 a.m. on Tuesdays. And this will probably be the first time either one is hearing any bills, and it's already the third week of March. Very, very unusual. As we've been saying in the halls of the Capitol, you can hear the echoes of the dying bills echoing throughout the halls. So I don't expect a whole lot to get done. Fewer bills were filed this session than have been filed in prior sessions by quite a few, about 300 to 400. Probably by the end of the session, it'll be about 400 total bills, less than the peak number from last session. So, but the big issues that are out there, which started off being the budget, the pandemic, and redistricting, have been further complicated by the big issue of the ice storm and the failure of ERCOT to keep the electrical grid up and running and providing enough power, along with the fact that it came very, very close to completely crashing. We were apparently within minutes of the entire grid going down, which I'm told would mean no power potentially for months. The good news is there's not a lot of groundwater bills. The bad news is there are lots and lots of local government or political subdivision bills that I'm having to track. My grand total number of bills I'm tracking right now is well over 100. I expect that to hit about 140 when it's all said and done, which is actually more than I've had to track in the past. But only a few of those are groundwater bills. I've only got 10 groundwater bills I'm tracking, and 6 of those 10 are companion bills. Senate Bill 152 by Senator Perry and its companion House Bill 668. By the way, there's another House bill there, House Bill 666, which is also identical but will not be pursued, are the 2 bills that were being pushed by the Farm Bureau. It's my understanding that both of them will be amended to match exactly what the Texas Water Conservation Association Groundwater Committee approved as part of its legislative package, and that was eventually approved by the board of directors of the TWCA, except for the section 1 of Senate Bill 152, which is a provision that would change the attorney's fees award provision from a guaranteed attorney's fees to a district, should a district prevail, to an option available to the court. Most of my clients are in opposition to that. I'm not sure how strong that opposition is. I think the House committee is in opposition to that, but we'll have to see as that goes through. I'm sure that provision will pass out of the Senate as is. Then there's also, you've already heard tonight about Senator Eckhart's bill, Senate Bill 946, and Representative Bauer's companion, House Bill 3619. This is something that was filed, if it wasn't last session, it was 2 sessions ago. And what it does is allows a district to consider the impact on registered exempt use wells in addition to the impact to permitted wells when granting or denying a permit. I cannot guarantee you that gives those entities standing to protest against a permit, but at the very least, it suggests that to be the case. And regardless if they have standing or not, they have to be considered. You will be required by law then to consider the impact on any of those wells. That doesn't mean that you deny the permit if there is impact. It simply means it's something you have to take into consideration. And then the House Bill 2851 by Representative Lucio, which would require during the DFC process, the desired future condition process, require consideration of the modeled sustainable groundwater pumping, in addition to the other factors, which includes what we call the TERS, or the total estimated recoverable storage. So it kind of creates bookends, 2 bookends to the entire process. On the one side, you have the total estimated recoverable storage, which is the most that could possibly be pumped from the aquifer, and then the sustainable groundwater pumping amount, which is the amount that could be pumped in perpetuity. And presumably the DFC would fall somewhere between those 2 numbers. Representative Metcalf has filed House Bill 3801, which is in part duplicative of a section that will be added, as my understanding, will be added to Senate Bill 152 that has to do with clarifying when a desired future condition is declared unreasonable, what desired future condition must a district use in its management plan? Should that management plan come up before the unreasonable desired future condition is replaced with a new one? That's exactly what happened to the Lone Star Groundwater Conservation District in GMA 14. The desired future condition for that district was declared no longer reasonable. They then had a deadline by which they had to file their management plan. They filed it without any desired future condition. The Water Development Board rejected it and said, no, the desired future condition is an absolute requirement to hold that your plan is administratively complete. They went through a contested process. They had a mediation process. They had, I think, a lawsuit was even filed. Eventually, they mediated the dispute and decided that they would use the 2010 desired future condition which is very unsatisfactory to everybody around because there was a very, very old number and didn't match any of the realities of either the district's policy or the current desired future conditions. What the bill would do is it would require that you continue to use the unreasonable desired future condition for your management plan purposes up to the point that a new desired future condition is adopted. So if the deadline for your 5-year renewal of your management plan should happen to come between the time that a DFC is declared unreasonable and the time that a new one is adopted, then you would be required to continue to use the unreasonable desired future condition. This version did get complete support, 90% consensus support from the Water Conservation Association's Groundwater Committee, and I would urge the district to support that version as well. I hope at some point we can do away with the desired future condition appeal process altogether and replace it with something that is more prospective, because by the time that you go through the appeal process, you're already well into the next round of planning to set the next desired future condition anyway. And if the idea is to give a minority viewpoint power to be heard, that can be done as part of that process rather than trying to appeal the prior desired future condition. I want to point out that several sessions ago, we removed the DFC and the MAG, what was then the managed available groundwater, as a permit limit. That permit limit language has been completely repealed, and now the modeled available groundwater, or MAG, is a consideration in the permit process, but does not represent a permit limit. So the DFC itself does not or cannot have any direct impact on any individual applicant's permit. House Bill 3972 by Chairman Tracy King will certainly get a hearing in the House. It's also been filed in the Senate by Senator Lucio, Senate Bill 1314. And that is a bill that would require, they're not identical, so they're not listed as companions, but they are in fact companions. They're trying to accomplish the same goal. It would require a person to file a surety bond before filing suit against a groundwater conservation district. It's a little bit confusing, and I think we're going to see a substitute on that bill that's going to clarify that where you have an entity that is filing a protest against an application, and the only reason that that application is going to contest a case hearing is because of that protest, that entity must put up a surety bond to help pay the cost or cover the cost of the hearing process for that protest. And then if there's a suit against a district, either complaining about their rules, Declaratory Judgment Act, or an appeal of a permit, that the person filing the suit has to put up a surety bond to cover the district's costs and the applicant's cost, if applicable, for their attorney's fees and other court costs for going through that suit. It would be something very similar to an appeal bond. Right now, if you have a monetary judgment against you and you want to appeal that decision, you have to put up an appeal bond equal to the amount of the damages that have been awarded. So I believe that this will result in something very, very similar. I have not heard anything about whether or not this is going to get a hearing in the Senate or how it will be received over there yet, but I'm pretty sure because Chairman King has filed it, it will be heard in the committee, and he probably has a pretty good chance of getting a committee substitute passed out of the House. So that's really all the groundwater bills. I'm not going to go through the other 90 bills that I'm looking at, 90 plus bills I'm looking at. I will mention that a lot of them have to do with open meetings, and a lot of those have to do with the ability to continue holding meetings remotely and under what circumstances and what all you have to do to qualify to be able to do that. There are a lot of bills filed right now about responses to the Public Information Act, both in terms of responding or not responding during a pandemic or other type of emergency condition or catastrophe, but others being more stringent about what you have to do in order to reply, that you at least have to respond in some manner within 10 days and provide information on Public Information Act requests. So there's quite a few of those. There are the bill that would prohibit the district from spending public money on hiring a lobbyist has been filed. There have been several versions of that. The one that has the highest number in the Senate, it's one of Lieutenant Governor Patrick's 31 priorities for this session, would only apply that prohibition to cities and counties and school districts, I think. So it wouldn't apply to other small political subdivisions, which was a big part of the contention with the bill this last session, in that this is really not, it's not a conservative versus liberal fight or even Republican versus Democrat. It's very much a rural versus urban fight. Again, trying to maintain the rural ability to have a voice in Austin. If anybody has any questions about these or any of the bills, please let me know. And if you have other bills that you would like me to track, Jim, did you all get a copy of the tracked bills I sent out over the weekend?
I don't recall getting that from you. I think the last thing I got the email from you about there was another fees bill that I remember you sent out, but I didn't see any. I don't remember seeing a track list from you.
I've heard from a few people now that the emails I sent out over the weekend didn't make it through, so I'm going to have to resend that. So I'll be sending Jim a complete copy of everything I'm tracking, a couple of the individual tracks by subject matter. So he'll be able to share that with you, the board members. And if there's other bills you would like me to add to that track list, please let me know. If there's anything on this list that you think that the board needs to take a strong position for or against, by all means, let me know that as soon as you can, so I can communicate those problems both to the bill sponsors and to the relevant committee members.
I'll cross-reference your list with the ones from the legislative committee meeting yesterday, and we'll get something put together back to you, to the board, and then on our website.
Okay.
Thank you.
Greg, one quick question, dumb question, but I'm sorry. You said at the very beginning of your presentation you had 10 groundwater bills, 6 of those that were something.
Companions. It's the exact bill that's been filed in the House and the Senate.
That's what I need to know. Thank you.
Any other questions for Greg? Okay, Greg, we thank you for your report and update. It's very important.
Very welcome.
I'm glad I'm not an electric provider anymore. Item 14, consideration of a board retreat. Really would like the board to give consideration to this. Some of you have suggested that to me that this is something very important to you. And so I'm going to put it on for an action item next month. And if you don't want to set a date, then we don't. But I do want to be responsive to those of you who have expressed to me that we've reached a point that it would be important to have a retreat. And any workshop, conferences, or meetings that you would like to attend, please get with Jim. And for our agenda, our next board meeting is 21st of April. And that's all I have for tonight, unless y'all have something else.
Mike, I think Phil cooking up something, and then I had something for this item as well. So,
okay, go, Phil, go ahead.
Mike, pertaining to the board retreat, in the interim between the next meeting, could Jim have his folks send out a calendar and find out who's, well, first of all, find out who's willing, and then find some dates so that at the April meeting, we could decide on a date.
Very good idea. Move it along a lot quicker, Phil. Thank you. We'll do that. I'll get with it. Thank you. Excellent suggestion.
And along that line, Director Sherrill brought this up at the meeting yesterday, and then we heard it again tonight in public comment. I just wanted to kind of get the board's temperature on the idea of moving back towards some form of in-person meetings. And this is also something that we need to look at for the, for a workshop or a retreat in terms of how we want to structure that. So we don't need a vote tonight, but
one thing I am
will send me what their thoughts are on how we want to proceed with in-person our meetings in the next couple of months. That'd be helpful for us to kind of figure that out.
Well, I do think there's going to have to be some work done. And one of the notes I made here, I want to put an item on an agenda next month to begin moving back to having a regular board meeting versus a virtual meeting, and what we need to think about in that transition, because there's still some compliance issues that we're going to have to deal with, or if the board's interested in it at all not. I don't want a lot of work being done if the board is still hesitant in having an open meeting. And as you heard from Mr. Ellis tonight, that issue is split 3 different ways, and how people are reacting to it. So before we have the staff go out and do a lot of work, I would just like to know if you would like us to investigate what's involved, what's it going to take to move. And I would also suggest that we probably, for the immediate time frame, if we decide to move in that direction, fix on one location, because that way it'll be easier to get set up and not having to set up for 2 different locations every time we have a meeting. So, and you can give your thoughts at the meeting, but I just like to get the ball rolling to see if that's something you want to pursue. Okay. All right. Is there anything else that needs to be brought to the attention of the board for the good of the district? The meeting is adjourned at 10:21.